This is Barry Zalma. I am an attorney, now retired from the practice of law, who keeps myself busy acting as an insurance claims consultant and insurance bad faith consultant, and testifying as an expert witness. I also write books and do these videos on YouTube. As we sit around, stuck at home because of the coronavirus, I thought it was useful to help people improve their knowledge of insurance. So that's why I keep doing these videos. Today we're going to talk about the examination under oath and how a false statement at an examination under oath will void coverage. Where a plaintiff admits to making false statements with the intent that his insurer rely on those statements, the issue of whether such false statements were made need not be tried. However, where a false statement was made knowingly and with the intent to deceive the insurer, it is usually a question of fact that may be decided as a matter of law where the insured admits that he made knowingly false statements with the intent that the insurer rely upon them. This is a case called Ram versus Infinity Select Insurance Company. The materiality requirement is satisfied if the false statement concerns a subject relevant and germane to the insurer's investigation as it was then proceeding. Like credibility, whether a misrepresentation is sufficiently material to void the policy is generally a question of fact for a jury to determine. The insured's intent to deceive is determined from circumstances indicating the insured's knowledge of the falsity of the representations made in the application or in the claim presentation. In Louisiana, for example, a court concluded that it was established at an insured's EUO, examination under oath, that he made a false statement on the insurance application regarding his wife's involvement in a bankruptcy in the 5 years preceding the application. This was a case called GeoVera Specialty versus Odoms. When a proof of loss submitted by an insured stated that certain bins involved in a fire had overall dimensions of 20 feet by 52 feet by 30 feet, when in fact the bins only measured 16 by 30 by 17.5, the misrepresentation required an EUO to clarify the claim and explain the allegation that the insured simply made an honest mistake. The court, faced with the allegations, concluded it was inconceivable that an insured could forget that there had been a fire at his or her property which caused significant damage when asked about it only a few months after its occurrence. The court's review of the relevant transcripts revealed that the insured made so many misrepresentations during the investigation of his claim and the litigation that he had been unable to keep straight what he had told the insurer's investigation and attorney, or even his own attorney. As a result, it became clear that there was a material misrepresentation by the insured that allowed the insurer to refuse to indemnify for breach of material conditions. This is a case called Thomas versus Armed Forces Insurance Exchange. Again, in Nationwide versus Brown, the U.S. District Court in Michigan dealt with the fact that Tamara Brown's conduct making repeated false claims during an EUO and the claim and settlement process entitled Nationwide to summary judgment. The contract contains two relevant provisions. First, the concealment, fraud, or misrepresentation condition provides in relevant part that Nationwide may void this policy or deny coverage for a loss if any insured person or any other person seeking coverage under the policy has knowingly or unknowingly concealed or misrepresented any material fact or engaged in fraudulent conduct in connection with the filing or settlement of any claim. Relatedly, the policy contains conditions preceding to coverage, requiring cooperation with the claims process and submission to examination under oath as often as nationwide would reasonably require. The source of the right to an examination under oath, as well as the procedures that govern such an examination, are also distinct. As the 11th Circuit Court of Appeal explained, quote, the right to obtain sworn statements, close quote, during an examination under oath, quote, arises from the policy provisions, close quote, and the right is thus, quote, contractual in nature, close quote. This is USF&G versus Welch, a 1988 case. The district court did not ignore the distinction between a deposition and an examination under oath. For this reason, the right to conduct such an examination is not to be confused with procedures authorized by statute for taking depositions. Generally, an examination under oath is not the same as a deposition, and during an examination, the examinee may lack certain safeguards available to deponents. There is no judge involved. There are no rules of civil procedure. The rules are whatever the insurer states they are. When the evidence is undisputed that an insurer undertook a thorough investigation and hired a professional engineer to complete an inspection and assess the damages to plaintiff's home prior to reaching its claim decision, when it paid plaintiff for living expenses and paid policy limits for the residence and its contents, the insurer also sought documentation from the plaintiff to substantiate his claim for the damage to tractors and conducted further investigation when plaintiff made inconsistent statements regarding whether the tractors were used for personal or business purposes. It attempted to obtain further documentation from plaintiff and schedule an EUO on numerous occasions. When plaintiff failed to appear for the EUO, the insurer denied his claim on the basis of his failure to submit the requested documentation and sit for an EUO, as well as for his apparent misrepresentation based on the unexplained inconsistencies in plaintiff's statements about the use of the tractors. As a result, plaintiff could not satisfy the elements of a cause of action for bad faith refusal to pay a claim. Further, the insurer also had a reasonably legitimate or arguable reason for refusing to pay plaintiff's claim for the damage to his tractors, and plaintiff has presented no evidence that the insurer lacked a debatable reason or that it had actual knowledge of the absence of any legitimate or arguable reason for refusing to pay his claim. This is a case from a case called Stewart versus Allstate Indemnity, an Alabama case in 2014. The case did not consider, although it should have, whether the insurer was entitled to return of the monies paid for losses other than the tractors, because the insured's refusal made the policy void. In Wagnon versus State Farm, a 10th Circuit case in 1998, the court applied ageless law in Oklahoma that making a false statement in an EUO voids coverage, as long as the misrepresentations were made knowingly and deliberately. The intent to deceive the insurer will be implied. The court relied on a U.S. Supreme Court case, Claflin versus Commonwealth, a 19th century decision. In Wagnon, State Farm was advised not to pay a claim by counsel and by its investigator after the following facts were adduced. 1. The fire department advised State Farm that in the opinion of its captain, the insured burned down his own house. 2. The insured left the house 16 to 21 minutes before the fire department received an alarm. The fire traveled downhill and not just uphill. And 3. There were multiple points of origin indicating to the fire department that an accelerant such as gasoline was used to cause the fire. Furthermore, the insureds were in dire financial straits at the time of the fire, a fact about which one insured had spoken falsely in his EUO. The insureds had claimed assets of considerable value in the house in the inventory submitted to State Farm, yet disclosed far less value in assets to their creditors in their simultaneous bankruptcy petition. Every potential fraud investigation should review filings in bankruptcy court, since bankruptcy petitions are filed under oath, and failure to honestly report your assets in a bankruptcy petition can result in time in the federal penitentiary. The court concluded that State Farm had no obligation to pay. The insured, perhaps, forgot that statements made in bankruptcy proceedings made under oath, as is the testimony at an EUO, force the insured to determine which contradictory under oath statement was true, when in all probability they were both false. In addition to false statements, failure to give complete responses to questions at EUO concerning prior losses is sufficient to allow the insurance company to deny a claim. Plaintiff's willful failure to make a full disclosure at EUO invalidates an insurance policy. An insured, for example, was found to have breached an automobile insurance contract by making knowingly false statements as to material matters with intent to deceive an insurer so as to void a policy under California law, in a case called Ram versus Infinity Select. During the investigation of his vehicle theft claim, the insured produced a W-2 form indicating he earned $90,000 in 2007. However, he later admitted his income for that year did not exceed $50,000, and the W-2 was created for the insurer and never submitted to the government. He also admitted he proved false information about his previous car insurance at EUO and in an affidavit submitted to the insurer, and falsely testified in the EUO that he had never before been a victim of a vehicle theft, and he admitted to making knowingly false statements with intent the insurer rely on those statements. This is very unusual, since seldom, except in fiction like Perry Mason, do people admit under oath to lying. It happens. It's happened in my career, rarely, but it's happened. And one should never rely on an insured admitting to false statements. It is the full and fair investigation conducted by the insurer in addition to the testimony at examination under oath that will provide admissible evidence that establishes the false statements. For example, in Thomas versus Armed Forces Insurance Exchange, the undisputed evidence established that AFI was entitled to void the policy because, based on Thomas's false statements, when he applied for coverage, Thomas informed the insurer's representative that there had been no losses at the property in the past 5 years, and that the property needed no repairs or improvements. These statements were just plain false, as in fact a fire had occurred at the property the day before, which caused substantial damage. In an affidavit submitted in support of his response brief, Thomas states that he called at 11 a.m. to obtain insurance coverage as he was about to evict tenants and move into the home. According to the fire incident report, the time of the alarm for the fire on that date was 11:38 a.m. Presumably, Thomas misrepresented the fire had not occurred when he made the above statements. As a result, Thomas was not entitled to relief on his breach of contract claim against AFI. Insurance cannot be purchased after a loss if not everybody would. No one wants to pay premium and never have a right to collect, and it would be wonderful if you could buy insurance after the fire to apply to the damages incurred in the fire that occurred before you bought the insurance. Insurance is a risk-spreading device. It is not a device allowing you to profit from a loss. Seldom do judges rule in favor of insurers who are considered less than responsible and who are considered to be so rich that they cannot be harmed even by a false claim. On occasion, however, judges cannot stand to be lied to. In a court case, a judge ruled and stated, quote, "Rarely in my years on the bench have I encountered such a palpably fraudulent claim and such incredible testimony as that of these plaintiffs. The three are no strangers to each other. Anna and Ben live together with their 2 children. Ben and Carlos are cousins, and all 3 plaintiffs work together at a Boston restaurant named Chadwick's. Anna admitted in open court that she had lied to trust the insurer in her examination under oath regarding the cause of her work disability, the alleged subject car accident, as opposed to the true reason, her pregnancy. She also confessed her false statements on her PIP, that's personal insurance protection, application concerning the beginning and ending dates of her purported disability due to the auto accident. At trial, she conceded she did not miss a single day from work because of the alleged collision. Ben's father, Emmanuel Neves, who the plaintiffs claimed was the 4th passenger in the car and who submitted a claim to trust for benefits asserted in his Fifth Amendment right against self-incrimination and refused to testify for trust at trial upon the advice of counsel. His earlier deposition testimony was admitted in evidence. Miraculously, the plaintiffs have survived a combined total of 8 motor vehicle accidents over the past decade or so. Carlos supposedly was injured in 4 other car accidents in 1993, 1996, 1998, and 1999. The 1998 accident allegedly occurred just 2 months after the incident in question. Ben claims to have incurred personal injury in 3 additional automobile accidents in 1997, 1999, and 2000 under remarkably similar circumstances, including being rear-ended by Hondas on 3 of those occasions. Anna asserted that she was involved with Ben in the alleged 1997 accident in which they were struck once again by a Honda. Close quote. As a result, the court not only dismissed the claim for injuries but ordered the putative plaintiffs to pay the insurer more than $23,000 for its prior payments and expenses. The case is called Pinto versus Trust Insurance Company, a Massachusetts court in 2004. Lying on an examination under oath is a first-class sin and a breach of multiple material conditions and warranties put out in the policy. It is therefore essential that whenever there is a suspicious claim, when evidence may or may not prove that an insured is attempting fraud, it is up to the insurer to demand production of documents and testimony at examination under oath. And if any false statement can be established at examination under oath, then the claim must be rejected in its entirety and the policy determined to be void. This video was adapted from my book, The Examination Under Oath, which is available as a Kindle book or as a paperback from Amazon.com and from my website, www.zelma.com, by linking onto the insurance claims library link at the site. Thank you again for listening, and I hope this has helped you understand a little more about the importance of the examination under oath to an insurer faced with a potential fraudulent claim.